population living in these polluted areas are also affected as well. So we can see the emergency, the urgency to address this matter, same as the third picture as well. So we can see that the situation is very dire and there's an urgency to address this environmental degradation in African countries, particularly in Nigeria. So basically, looking at, I haven't shown you a graphic picture of the current situation. This slide talks about the underlying reason why businesses continue to pollute the environment. For example, why are they so interested about the bottom line? Why don't they really care about the environmental impacts of their operations? And so I'm going back to the theoretical foundations of why this is so. And this brings me to the corporate purpose question and the sustainability discourse, which talks about for whom are directors responsible. So are directors responsible to shareholders alone, which means they continue to maximize profit for shareholders, and then the environment continues to suffer? Or are shareholders supposed to pay attention to broader interests? For example, the environment. For example, the lives of the citizens are impacted by, gas flaring as well. So in the 1930s, we have this famous scholar from Harvard Law School, Professor Adolf Bell, who was of the opinion that directors should just focus on maximizing shareholder interests. In the same year, Professor Bell disagreed with what Adolf Bell said and stipulated that that is not fair. Corporations do not exist in vacuum. Indeed, they exist in a society. Indeed, they exist in communities, and it's important for them to pay attention to the impact of their operations on the environment. It's important for them to pay attention to the well-being of those that their operations are making impact on. Similarly, also Milton Friedman, one of the famous economics in the 1970s, also published an article in the 1970s where he mentioned that what Dodd is saying is not really feasible, because insofar as businesses stay within the rules of the game, then they need to maximize shareholder profit. And Freeman also countered what Professor Milton Friedman said and stated that Professor Freeman brought about the stakeholder theory, and he was of the opinion that directors should not only pay attention to the interests of shareholders, but they need to consider the interests of the stakeholders, which includes community, the society, supply chain, the environment, and other aspects. So directors shouldn't focus solely on environmental, on the shareholders' interest and the bottom line, because in the long term, that will be damaging for their reputation. For example, we've seen cases of the Rana Plaza, in which there was a collapse in Bangladesh. Until date, some lines like Adidas and Co, they've been blacklisted by some NGOs as being irresponsible, which is damaging for their profit in the long term. So Freeman brought about the stakeholder theory and said, why should we focus on shareholder interests alone? We need to pay attention to the interests of those that are also affected or impacted by business decisions. And so that debate, till date, this debate has been a hot debate. But interestingly, many countries are sticking to Bell and Friedman's arguments because it's convenient for them. Many countries want to improve their bottom line, right? They want to improve their economy. But what they don't seem to understand is the fact that you need to have an all-round sustainable economy. You can't focus solely on economic gain and neglect the citizens and their interests and their health and the damage that some businesses cause. So in furtherance to this, this debate has been resolved mostly in favor of the Bell and Friedman's view, unfortunately. However, in order to address this matter, my study brings up a new model, which is the environment responsibility model. Now, in the environment responsibility model, I'm talking about the fact that, we are not saying that shareholders' interest should not be, taken into consideration. Of course, they put funds into the company, but then directors should not focus solely on the interests of shareholders. They need to pay attention to the interests of other people that are impacted by business decisions, particularly the environment. The reason why I'm focusing on the environment is because, for example, we have consumers. Consumers have a way of, stating their plight. For example, consumer boycotts. A consumer can decide, or many consumers can actually decide to not shop with a particular company or deal with a particular company. So they have a way of, stating how they feel. Also, when we look at employees have trade unions, right? And then these trade unions also can fight for them. But when it comes to environment, to a large extent, there's nobody that is standing for the environment. Environment cannot speak on its own. So that's why I'm really interested about this environmental responsibility, in cases whereby when directors are making decisions, the environment and the interests of shareholders are considered together at the same time. And also they can also pay attention to the interests of the employees, the market, the suppliers, the community. But however, environment is really important because we need to meet up with the UN SDG goals 2030, and time is running out. Apart from that, even in developing countries like Nigeria, for example, we need an urgent policy shift in order to tackle these dire environmental problems. Now, earlier on, I said I was going to carry out a comparative study in order to examine how countries have taken steps similar to the shareholder primacy model in Nigeria, how they've taken steps to promote environmental interests, despite the fact that they adopted the shareholder primacy model stipulated by Friedman and Bell. So we have South Africa. The first country I'm going to look at now is South Africa. Now, South Africa Corporate Governance Code, interestingly, adopts the stakeholder inclusive approach. According to King 4 code that's the latest corporate governance code in South Africa. King 4 code states that directors owe their duties to the company and the company alone, as the company is a separate legal entity from the moment it is registered until it is deregistered. And the company is represented by several interests, and this includes the interests of shareholders, employees, consumers, and the environment. So we can see here that South Africa has taken more steps than Nigeria, for example, to include that they clearly adopt a stakeholder inclusive approach. And why did they actually focus on this? Now, we are aware that South Africa had these historical apartheid issues where people were not treated equally. And then so when they were rebuilding their policy system, they brought about the stakeholder inclusive approach, whereby shareholders, the environment, the community, the employees, everybody is on the same level. And so no one's interest takes priority. And this was also based on the South African tradition, which talks about Ubuntu. We can see in the picture of the whole communal belief that we have to share everything we have. And Ubuntu comes from the word I am because we are. Now, it's an African adage that says that because I am, then we are. So we need to take care of everybody at the same time. So this Ubuntu tradition, this Ubuntu belief, is part of the very strong reasons why South Africa created the stakeholder inclusive approach. It's important to note that although progressive, this approach, this stakeholder inclusive approach, is in the soft law. And soft law, I wouldn't say soft law is not effective. Soft law serves as a nudge for businesses, but it doesn't have that enforceable notion. It doesn't have that strong sanction. So, but then it's a step in the right direction. And also, interestingly, case laws have also paid attention to the requirements of the code. And we can see in the case of this, the Forestry Ministry of Water case, where the court held that directors cannot simply walk away from their obligation towards the environment. They actually have a duty to protect the environment, and they should not solely focus on maximizing profit alone for shareholders. So we can see that although it is soft law, but the courts are interpreting the requirements of the code. So that's a step in the right direction as well. Also, another attempt, apart from the director's duties in which they brought about the stakeholder inclusive approach, we also have the King 4 code. And when we're talking about the King 4 code, he also talks about integrated reporting. Now, this integrated reporting is quite unique, meaning that over the years, even in Nigeria, reporting has focused only on the reporting system is basically report on financial interests separately, report on environmental interests separately. But this integrated reporting fuses both financial and non-financial reporting in the same document. So therefore, when directors are making decisions about their financial interests, they also have to pay attention to the environmental impact of their operations, and they need to report about it, because nowadays we all know with the whole ESG and climate change rise, investors are now really interested in the companies that they invest in. So this integrated reporting provides like a holistic approach. It provides a full picture on how they can engage with companies, and they are aware now that, okay, this is how a company pays attention to the impact of the operation on the environment. And it makes it easier because both documents are in, both financial and non-financial are in one single document. So that's a very unique approach from South Africa. And it's important to know that although impressive and progressive, this is also in the soft law, not yet embedded in the hard law. Now, so again, when we're talking about what does integrated reporting really mean? Now, we have the integrated reporting process. This process is built on integrated thinking. According to South African Corporate Governance Code, the aim of this is not only to give a nod for directors to produce this reporting. No, the aim is to promote integrated thinking. So in the thinking and the thought processes of directors, they are aware that whenever they are making decisions, they need to pay attention to the interests of the environment. And then it is through that thinking, we now have the integrated reporting process. So here, they need to, first of all, review, identify the sustainability issues and risk in a particular operation or in their day-to-day activities. And then they will now create like an action plan in which they intend to adapt to the sustainability and core business strategy as well. And then we also have the implementation and monitoring, and also then they have the preparation of the integrated report. So it is this integrated report that they're going to publish perhaps on their website or whenever the regulator comes in. And then this will now create informed decisions, like I mentioned earlier, for stakeholders to make their decisions on whether or not they need to invest in this company or they need to work in this particular company. So we can see that South Africa has two initiatives from what we've seen from the comparative study. They have the stakeholder inclusive approach in relation to directors' duties, and they have the integrated reporting model of reporting. I know the next one is Nigeria itself. And like I said earlier, although we have the corporate governance code, but it's not so solid, it's not so strong, it's still separate. So we have disclosure under the NCCG Code 2018, which says that the company's corporate governance report should include the following: highlights of sustainability policies and programs covering issues such as corruption, community service, including environmental protection, serious disease. And so basically, this is a separate document and not included in the financial document compared to the integrated report. So Nigeria is still behind when it comes to reporting of sustainability matters. Again, looking at the fact that we have impressive steps by South Africa, for example, where they have the progressive soft law requirement, but interestingly, there are limitations to soft law. Like I said earlier, soft law is voluntary and is non-binding. So what do I mean by voluntary? Voluntary means that it doesn't have any force of law. And then when something doesn't have force of law, then companies may choose or choose not to comply. Again, there are no fines. So because there are no fines or any force of law, businesses may choose not to comply with the requirements of the code. This is especially so if the corporate law hasn't recognized what the soft law is requiring companies and businesses to do. Again, we have market pressures. Now, what do I mean by market pressures? In terms of market pressures, most times investors also pressurize shareholders and even directors to focus on their own interests. This is based on the fact that investors have they need to maximize profit as soon as possible, so they pressurize directors to ensure that they focus on their interests first. Aside from that, we also have the executive compensation. We can see that when it comes to executive compensation, for example, most times shareholder value is tied to directors' compensation, and then that serves as an incentive for directors to continue to focus on shareholder interests, despite the fact that soft law is stakeholder oriented as well. So we're looking at, having discussed about the soft law, now we're looking at the next slide is going to talk about the corporate law attempts in Africa, for example. Interestingly, Nigeria in 2020, shortly during the pandemic, after 20 years, we amended our corporate law. Now, the corporate law in 2020 says that directors are to act in the best interest of the company, and in doing so, have regard to the impact of the company's operations on the environment. To be clear, this is the first time that Nigeria corporate law recognizes the environment. Over the years, there's always been shareholders and employees. So this shows that the Nigerian government is aware of the importance of paying attention to environmental interests. Unfortunately, again, this is similar to what other developed countries have adopted in form of the enlightened shareholder value approach, which says that directors have regard. And when you say directors should have regard, what does have regard really mean? Over the years, scholars have defined have regard to mean consider. So meaning that it's like a secondary issue. Still, shareholder interest remains paramount in this stead. Same thing with Kenya as well. We can see that one common denomination with all this is the fact that these countries are still sticking to the shareholder primacy model of corporate governance, which is a serious hindrance to promoting environmental interests, because directors need to be clear on what they're supposed to do. Now, if you're saying directors, they need to act in the interest of the company, and in doing so, they should have regard. So you're saying that directors should, first of all, focus on environment, on shareholder and the company's interest. And then if they have time, or if there's space, they can have regard. So again, this is strengthening shareholder interest and then putting environmental interest at the at the back front, and which cannot be effective in promoting environmental interest in line with the UN Sustainable Development Goals. In South Africa, we can see that South Africa, again, in their corporate law, has brought about the establishment of the Social and Ethics Committee. Now, this Social and Ethics Committee is responsible for supervising the company's environmental policies and implementation. This is an interesting phase because it kind of puts like some sort of checks and balances for directors, and also for people to be aware of what they are doing. Now, they need to bring to the attention of directors how their businesses are paying attention to environmental interests. And also says that Section 76.3 says directors' duties are to act in good faith and in best interest of the company. It is important to know that here, what interest of the company means is not clear. So again, the corporate law in South Africa, although makes provisions for the SEC committee, but still it's a shareholder focus, because there hasn't been a clear duty, there hasn't been a clear rule that directors should pay attention to environmental interests. In the UK, we have the enlightened shareholder value. The famous Section 172 points out that the director of the company must act in a way that he considers in good faith will most likely promote the success of the company for the benefits of his member as a whole, and in doing so have regard. So this company law was formulated in 2006. So we can see that rather than Nigeria making steps, perhaps we missed that opportunity again in 2022. Improving on this, Nigeria just copied the UK style, which so many scholars over the years have criticized as being ineffective in promoting stakeholder interests and also environmental interests. So again, Nigeria keeps going backwards instead of moving forward, and they missed that chance in 2020, rather than them enforcing a brand new model, a brand new policy-making style to ensure that environmental interests are put at the heart of directors' duties. They just simply copied the enlightened shareholder value, which has been criticized as being ineffective over the years. Again, like I said, one of the limitations of this corporate law regulatory attempts is the fact that we have the shareholder model of corporate governance. In the absence of clarity on what directors are supposed to do, the shareholder model is very clear, and directors will keep maximizing shareholder, and citizens will continue to suffer. Like we can see in the graphic picture I presented earlier, the situation gets worse. I'm sure that at the moment, particularly in the Niger Delta areas, people are having health issues, breathing problems, asthma problems. So it's not only the biodiversity loss that we're experiencing, we're also experiencing a threat to humanity. We're experiencing a threat to human existence, and this has to be fixed as possible. Unfortunately, again, the shareholder primacy model serves as a hindrance to promoting environmental interests. Again, CSR is viewed as philanthropy. We can see that over the years, businesses in Nigeria, they think when we're talking about CSR, we're talking about philanthropy. Although philanthropy is part of CSR, for example, when you build churches for communities, when you build schools for communities, yes, that serves as CSR, but that is not what CSR is only about. CSR goes to the decision making in businesses. It goes to the very heart on how businesses operate. So unfortunately, in African countries like Nigeria, they still view CSR as charity. When you ask, if you ask, an average company, when they are, providing, helping with education, providing sewing kits for businesses and women and all that, that is not the only thing CSR is about, but they view it as philanthropy. And so that's a hindrance in actually embedding sustainability in corporate governance. And also, again, like I said earlier, one of the limitations of this is the soft law. We can see that when it comes to South Africa, for example, they have an impressive style, but this is contained in the corporate governance code. Now, again, apart from the fact that it's contained in the corporate governance code, we have also seen that this shareholder value is further amplified in the fact that even in cases where, for example, directors fail to have regard to environmental interests, who brings up these proceedings? Are there provisions for citizens, or let's say, for example, environmental defenders to bring forward this? The answer is no. At the moment, only the company, which is shareholders, can institute proceedings. So in cases where, for example, environmental damage, doesn't affect shareholders, they may not bring up the proceedings, and they are the ones that can bring up the proceedings in court. So again, stakeholders are affected, cannot institute proceedings against the requirements of the law in the Companies Act. So this is a huge problem because it further amplifies the shareholder value. It further amplifies shareholder power. It further amplifies shareholder value as well. So one of the potential reforms is for Nigeria, in terms of incorporating sustainability into corporate law, is for Nigerians to focus on holistic reporting. Now, when I say holistic reporting, is to embed the integrated reporting. Now, like I said earlier, South Africa has introduced integrated reporting, but it would be very interesting for South Africa as well, for Nigeria to, embed this style, but in the corporate law. Now, we are aware that when we have when there's a force of law, when there are fines included, when there's this fine, and that if businesses don't pay attention to environmental interests, they'll be subject to fines, for example, then the citizens, human beings, react to that. So if integrated reporting is in Nigeria's corporate law, for example, that's the Companies and Allied Matters Act, for example, the citizens will want to, find all means to ensure that they report on how they've paid attention to the environmental impact, and then open them for scrutiny, and then open them for the ability to also make a change as well. And also the Sustainability Committee, which is not new to the corporate law landscape, can also be embedded in corporate law as well. And then in terms of the real approach to directors' duties, this study prefers the environmental responsibility model, which I mentioned earlier in my introduction. Now, the environmental responsibility model, again, says that the environmental interest and shareholder interest should be considered at the same time. In fact, if need be, if the impact, of business operations is going to cause an irreparable damage, irreparable loss, and destruction of lives and property to the citizens that were peacefully living there before the country is operating in, then environmental interest comes first. I think this is very important, at least for this moment, in order to tackle this climate emergency that we have at the moment. And then when we talk about how the ERM framework will work, first of all, there has to be a clear definition of what the term interest of company means, and also sustainability reporting, which I've mentioned, which is now integrated reporting, has to be subject to external verification as well. And we have the ethics committee. Again, like I mentioned earlier, one of the big problems that directors face to date is the fact that executive remuneration is tied to shareholder value. Now, if we can severe that and ensure that executive remuneration is tied to sustainability performance, then directors may be inclined to actually pay attention to environmental interests. Until that is solved, until that is realized, shareholder pressure will take will still be paramount, shareholder interest, because if they are confident, because if they pay, the directors may have this dilemma or this conflicting decision-making process whereby if they think that they need to pay attention to interests of the environment, then shareholders might institute proceedings against them based on the requirements of company law that says, directors should pay attention to the interests of shareholders. So it will be important for this to be clearly stated, like I said earlier, and also ensure that remuneration is tied to sustainability performance. Over the years, we've seen that board diversity can also serve as a tool to promote environmental interests. That is so in some countries, in developed countries. For example, the UK, having more female on board, for example, women are seen to be more passionate. I'm not biased because I'm a lady, but women are viewed to be more passionate. Women are viewed to be more environmentally inclined than men, for example. So having more women on the board can also serve as, it can bring a different idea to the table, can bring a different view to the table, and ensure that actually the directors, the entire board, pay attention to environmental interests, even also ethnic diversities as well. Minority groups, particularly those that have been subject to the experiences of negative impacts of the operation of businesses, not only on them, but perhaps their family members, for example, can also, if they are given the opportunity, and they must be highly skilled and qualified to be on the board in the first place. And then if they are given the opportunity to actually be in this room, board environmental interests will be promoted. But unfortunately, based on my research, this cannot happen in Nigeria. Why? Because in fact, we don't have diversity laws in Nigeria. The last one was struck out at the House of Senate. They tried to ensure that there was equal representation of women on the House of Reps. Note that this is just the public sector, and we found out that this was struck out. So even in the public sector, the legislators in the House of Senate and the House of Reps are yet to pass a law to promote equality of women, even in the House, talk less of the business sector. So at the moment, unfortunately, this board diversity, although effective, can be useful for developed countries. But for Nigeria at the moment, unless it's embedded in the hard law that directors have to have an amount of quota of women or ethnic minority groups or something, board diversity may not be a useful tool to promote environmental interests. And as I said earlier, till date, I don't think that can happen yet, because even at the House of Senate and Reps, that bill was struck out. And so, board diversity may not be used as a tool to promote environmental interests in Nigeria. And thank you so much. And I'm open to questions.
Thank you very much, Dr. Omisore. I will read out some of the questions that the attendees do have. So for the first one, we have from our very own Executive Director, Dr. Wole Kunji, who's asking, does the environmental responsibility model pose any risk or risks in terms of companies' ability to maximize shareholder profit? If it does, how can these risks or risks be mitigated? Thank you.
Yeah, thank you so much for that question. I think that in this kind of situation, at the first instance, companies may have to sacrifice some profit, but that is just at the first instance. And then, but in the long term, if businesses are operating in the long term, they will realize that they will have loyalty of customers. We have seen instances where customers make decisions based on the environmental responsibility plan of a particular business. So they have loyalty from their customers, and then they also have more profit. So, but in the short term, they should not expect to have as much profit. But in the long term, they need to think long term. And then, but when they think long term, the profits will come. But being realistic, when you adopt this model at the first instance, there has to be an understanding that there won't be massive profit as it used to, because there's some sort of sacrifice, in place. So yeah, so that's how it can be. And then in terms of mitigating the risk, to be honest, there's an emergency to protect the environment, and I'm aware of that. But we need to ensure that the citizens are protected. There's threat to humanity. So in this issue, we need to ensure that environmental interests are taken seriously. But again, like I said earlier, if the impact of companies' operation on an environment wouldn't cause so much damage. If the damage can be repairable with effective environmental assessment tests, then they can go ahead and put shareholder interest first. Unless that is solved, then at this point, they need to, they will sacrifice profit at the beginning. Nothing is going to, avoid that. But then in the long term, we will talk, businesses need to look at the long-term goal of a particular company, unless they don't want to survive for a long time. That's when the problem will be in. Thank you. Did I answer the question?
Hello. Please to the second question. Please,
Okay.
can you hear me?
Yes, I can hear you now. It's clear now.
Okay. All right. Thank you. So Stella is asking that as a layman, a lack of environmental sustainability in corporate governance does not seem like a very germane problem facing Nigeria. At best, it's shown something faced by people living in the Niger Delta. How can it be brought to people as a matter that everyone should reckon with?
Okay. Thank you very much for that question. I think that, I know that the Niger Delta people are the people that are most impacted, but we also have pollution in cities as well. We also have, flooding as well, right? So when we talk about environmental sustainability, basically, it doesn't only cover, those in the Niger Delta, but then we also need to create awareness that even the cities are becoming affected, right? Is a serious problem facing the people that are mostly impacted are the people in Niger Delta. But then even we cities in Lagos, there's congestion, there's air pollution by businesses, which also affects health. There's gas flaring by businesses as well. So most times people think that these environmental issues happen solely in a particular area, but then we living in cities, Lagos, Abuja, other places are also are affected as well. So we can also bring it to the people. And I like the fact that you highlighted that how can this be alerted to people, because we're about 120 million or even and counting in Nigeria. So many people are not even aware of this environmental impact. So we need to create more blog posts, more presentation and conferences like this, for example. We need to also have some, perhaps talk to policymakers, because most of policymaking, perhaps are focusing, they are shedding their light on something else. But again, we need to have more of these talks, more of presentation, more of hosting media, media meetings, just to create the awareness. Because like you said, and which I totally agree, people think that, environmental issues should be aside, but it is actually the dire of human existence and should be adequately paid attention to. That's a very good question. Thank you.
Thank you very much, Dr. Omisore. On to the next question. So Ronke is asking, she's saying also, what is the solution to the limitation of the inability to institute legal proceedings?
What is it? Come again. Can you read the question again?
What is the solution to the limitation of the inability to institute legal proceedings?
Okay, thank you very much for that question. Now, one of the solutions, because at the moment, if citizens don't have power, or if there's no stipulation in the act, then they can't go to court. The court, I'm sure so many of us are lawyers here, the court will ask you, what's your local standard? Institute this proceeding in court. So the solution is to ensure that these legal proceedings are embedded in corporate law. At the moment, corporate law only recognizes shareholders as eligible parties to bring about these proceedings. In order to ensure that, citizen victims that have been affected by this pollution, affected by environmental degradation, can actually institute these proceedings, for example, it needs to be included in hard law, so that will give them power to institute these proceedings.
Thank you very much, Doctor. So there's a question. There's another question. So Ronke is asking again that in a situation where government officials who have the duty of ensuring environmental protection and sustainability are also parts of the shareholders of the company, how then would the law guide against the conflict of interest as a government official and a shareholder?
That's very interesting. I think that's one of the problems that Nigeria has at the moment. For example, in America, I'm aware that once you become maybe a House of Rep or a Senate member, you have to, and you have shares in Chevron, for example, you are, required to withdraw your interest from that or withdraw your investment from that company, and you can't be part of the company. But as it is in Nigeria, I think that hasn't happened yet. So that's where the conflict of interest, again, the law can provide for this conflict of interest situation and ensure that, officials that are decision makers, for example, should not have shares in these companies because to a large extent, if I am a lawmaker and I have shares in Shell or Chevron, for example, when they bring it to my table, obviously I will be tilting towards boycotting for the company I'm a shareholder in. So I think one of the solutions is for the Nigerian government or any developing countries government, for example, to stipulate that once you become an office holder, you should divest your shares from a company that that is under scrutiny, from a company that has that propensity to damage the environment or any other welfare of stakeholders. So I think that's one of the ways in which perhaps Nigeria can draw lessons from the US, for example, on this matter.
Thank you very, very much for that answer. Another question is from Lois. Lois is asking, how would small and private companies incorporate CSR initiatives, especially given their smaller budgetary allocation in comparison with multinationals? Would you propose collaboratory schemes?
Okay. Thank you very much for that question. That's a good question. Now, I mean, small and private companies I wouldn't say has caused so much impact compared to the large multinational companies, right? But then there can be some sort of collaboration. I agree that there should be some collaboration between the large and small companies. Interestingly, in fact, these small companies, have more ideas on how they can work with large companies. So in some developed countries, there's some sort of collaboration between small and large companies. However, they need to pay attention to the competition law, right? So competition law comes in here to ensure that perhaps businesses in the same line of business. So let's say, if they are in the same oil company line of, they need to be careful. There are some documents that they need to sign stating that they are only collaborating for this purpose, right? So, but I totally agree that because they are smaller companies and they don't have as much money, and in fact, they don't cause as much impact. Most of them just have maybe generators that make noise and also, but they cause pollution as well, but they can collaborate with these large companies, but paying attention to the legal effects of competition law on their collaboration. I think that can work, but competition law requirements need to be clearly adhered to in that instance. Yeah.
Thank you very much, Ma. On to the next question. Stella is asking, she's saying that you mentioned consumer conduct as a way of enforcing corporate responsibility for the environment. Using Nigeria as a case study, and according to your research, is it possible or feasible for Nigerian consumers to take a stand about such, despite current socioeconomic realities?
Okay, yeah, I think that this is a very good question. And I'm very, very aware that the economic situation at the moment isn't so isn't so friendly, for example. But they can still, it depends on what their convictions are, right? Consumers can, let's say, for example, again, this brings to the question one of the members asked, where he or she mentioned that, how can we create more awareness? Now, when we create more awareness to citizens, the chances are slim that even if you don't have much money, for example, with your little quota, you can ensure that you invest in businesses that, or you buy from companies that are more environmentally sustainable. But at the moment, I'm aware of these harsh realities that consumers are, maybe they want to cut costs. They will be like, oh, I don't really care whether they are damaging the environment or not. Let me like just have something for my family. Those are exceptions. But most consumers, when they are being told of this impact, I mean, humanity recognizes humanity to a large extent, right? And then so when they are being informed about the damage that these businesses have done, the damage that lack of concentration on environmental interest has done, then I'm of the opinion that consumers can serve as a push to enforcing environmental sustainability. Yeah, I think they can. But just
thank you very much.
Yeah, thank you.
Sorry. Thank you very much, Ma. Please to the next question. Monia is asking, how do we make people aware of the soft laws that exist so that they can become hard laws in the nearest future concerning environmental laws and sustainability?
Interesting. Now, in fact, at the moment, we don't even have in Nigeria. I know that in South Africa they have good soft laws. So we have the stakeholder inclusive approach, and then we have the integrated reporting. That's for South Africa. Unfortunately, in Nigeria, we are nowhere at the moment when it comes to embedding environmental interests even in the corporate governance code. So I think the first thing, first of all, is to have this requirement in the soft law, discuss with policymakers. How will businesses accept it? Would there be a huge rejection, or would they accept it wholeheartedly? So I think that the first thing is for us to even have that stuff, for us to even embed it in the soft law, first of all. And then once we have that in the soft law, then if businesses are interested in that, and the policymakers are also interested in it, then we can go ahead with the hard law. But at the moment, we don't even have soft law on environmental sustainability in our corporate governance code. But then for other countries like South Africa, they have soft laws. But for the corporate governance code in Nigeria at the moment, we don't have explicit stakeholder inclusive approach in our codes. It's still largely shareholder focused, which needs to change over time with much pressure, hopefully.
Thank you very much, Doctor. I'll move on to the last few questions. Okay, so Daniel is asking, what is the best way to influence policymakers towards making environmental sustainability laws?
That's a very good question, Daniel. I think in this kind of situation, how can we influence them? We need to change culture, right? So when we talk about culture, everybody has to be on board. I'm aware that so many citizens aren't so aware of this whole climate change issue, the fact that there's an emergency, there's an urgency to address environmental interests, and that needs to change. So first of all, culturally, we can influence policymakers. When I say culturally, I mean that when citizens are on the same page, highlighting the importance of these environmental sustainability laws in the corporate law and corporate governance code, I think that will be a change. Secondly, we need those in the academia, we need politicians, we need businesses as well to push for this, because again, when businesses push for it, it gives everybody a level playing field. Like I mentioned earlier, I'm aware that there are some businesses in Nigeria that are paying attention to environmental interests. On the other hand, some businesses don't do anything. So the law, having a law on this, will put everybody on the same level, right? So when I now talk about culture, everybody has to push for this. I remember the EndSARS protest then. I think that there was a unison, there was an agreement, right? So if we can have that in relation to environmental sustainability laws, I think that will make a great step in the right direction.
Okay, thank you very much, Dr. That's to the last two questions. So first, I want to ask that, would you say that incorporating extensive information on environmental protection and CSR policies and initiatives in the educational curriculum of institutions in Nigeria would go a long way to create awareness and propel some change?
Yes, but that will be for when you talk about education. Are you talking about primary school education? Are you talking about secondary school? Are you talking about university? Are you talking about MBA level? So I think that would be a great step. I'm aware that some people, some activists are pushing for, having that climate change sustainability in the school curriculum. I'm of the opinion that, yes, that would be very useful. But however, that wouldn't be the only solution. We also need other civil society actors to push for this. But yes, particularly when it comes to maybe in primary schools, in secondary schools, right? Even in university, I think that would be good, because I remember while growing up, I don't think we had a climate change curriculum. And then until we went to, perhaps maybe when we came to the UK for our masters or more or less university days, that was when we knew about this. But if, for example, you train them from primary school level, they can get home and talk to their parents, right? And their parents are adults, and parents sometimes, listen to their children. And then so that can enforce that change. So yes, I support that educational curriculums can make that change to create that awareness for people as well. That's a very good point.
All right. Thank you very much, Doctor. On to our very last question. 1K wants to know, do you think citizens can institute legal proceedings on environmental sustainability against the government in light of the non-justiciability clause of the Section 66C of the Nigerian Constitution?
I mean, that would be, to a large extent, that's not like a direct enforcement mechanism, but they can try. But that's not a direct enforcement mechanism, but they can still try. That's why I'm pushing for corporate law and corporate governance, because that gives citizens more power, to actually enforce their rights. But they can try. I'm not really conversant with Section 66C, which I'll look carefully afterwards, but they can still try and look at it.
Okay, Ma, thank you very much. We do have one last question. I'm sorry, I said that was the last. Okay, so Lois wants to know, she says, in Nigeria, many oil multinationals engaging in CSR are also complicit in environmental degradation. How do we reconcile this contradiction in environmental ethics?
Thank you very much for that question. I think I said it earlier that many of these multinationals, right, they think CSR, because they're in Nigeria, and again, because there's large poverty in the country, so people feel that when businesses, for example, build schools, I've seen so many multinationals building schools or building churches, for example, and they still continue to pollute the environment. I think there has to be a reorientation of what the laws are saying. The law has to clearly state that although philanthropy is part of CSR, because this other engaging in CSR activities is called philanthropy. So there needs to be a clarification of the laws that philanthropy is part of CSR, but then that is not only what CSR entails. So again, in the corporate law, there needs to be a definition. When there's a definition, then if you as a citizen, you are going to institute a legal proceeding, you can rely on that definition, right? So there needs to be a clear definition of what CSR means. CSR is not solely on building schools. It's not on building public toilets. It's not on building boreholes alone. However, that is part of CSR, but that is not what CSR really entails, right? So CSR goes more than that. It goes beyond that. So it goes beyond that. It pays attention to businesses minimizing the negative impact of the operations. It focuses on, reducing their carbon offset, reducing gas flaring. So that is it's an all-encompassing. So in this kind of situation now, the first thing is to clarify what CSR means. Now, businesses, oil multinationals are taking advantage of the fact that we don't define what CSR is. So they define it for us based on what suits their own pocket or suits their own profit-making idea. So we need to take charge, take hold of who we are as a country and define CSR. CSR is not solely on philanthropy, on charity obligations, but it goes beyond that. It goes by paying attention to the impact on the environment, paying attention to employees' interests, paying attention to the society, paying attention to the welfare of the community and all that. So stakeholder engagement as well. So that is an all-encompassing thing, what CSR is. So at this point, I wouldn't say there's a contradiction. More or less, they're having their way with the lacuna in our laws at the moment in Nigeria. So we need to fix that first. If not, they will keep building schools. And unfortunately, because citizens, are desperate for those amenities, they are happy. But that doesn't last for long. The environment is still being depleted, right? And it's getting worse and worse and worse every day. So we need to take back that opportunity to define what CSR means so that multinationals won't define it for us. And that is what's happening at the moment, taking advantage of the poverty level and unemployment rate in the country.
Thank you very, very much, Dr. Omisore. That was our last question. Thank you for the very insightful presentation. At this point, I would invite our Executive Director, Dr. Wole Kuneji, to give us his closing remarks.
Thank you so much, Ibukun. That was a very wonderful one, very brilliant presentation. Thank you so much. And I think that this particular presentation is coming at the right time. The Nigerian government now is looking for investors. They want people to come and set up businesses in Nigeria and all of that.
Yes.
But like you mentioned, we should not focus on just getting investors to come to Nigeria alone. We should also pay attention to the impact of their businesses on the environment. I think that's very important. And from all indications, I think this particular topic is a very interesting topic. From the questions that people, some of my people here have been asking.
Very good questions.
Yeah, very good questions. So I'm thinking that at some point, maybe later in the year, we may want to probably organize an ESG seminar. And I know you did something with the World Bank like 2 years ago. Was it 2 years?
Yes,
on
yes.
ESG. Yeah. So we'll certainly invite you.
Okay,
we'll discuss. So because I know that ESG now is like hot potato. Everybody is talking about ESG. Most companies are having ESG departments. I have friends now that work in companies where they have like an entire unit dedicated to ESG,
Amazing.
Yeah, so that's happening. And I think people need to know, especially students.
Exactly.
Law students that are, rounding up their studies need to know that there are even career opportunities in that area.
That field.
Yes, that field. Many companies now, many big multinationals now have ESG departments. Many of these international development organizations have their own ESG departments and all of that. So I think it's a good one. KPMG, PwC, many of these consulting firms now have, they now do a lot of ESG work and all of that. So our students need to even be aware that, yes, this is something that they can specialize in later, Yes.
So, and I feel like a win-win situation.
Yes, it is. It is. So, I because as you were, doing your presentation, I was thinking that I think we need to have like a seminar on ESG at some point later in the year. So,
I agree.
You'll be a major resource person for that seminar.
No worries. I'm at your service.
All right.
Yeah. I'm at your service anytime.
All right. Thank you. Thank you so much. Thank you so much. And thank you so much to all our interns that asked those brilliant questions. Very brilliant questions, I must say. We continue to have our monthly seminars. Dr. Asolo from Alukanoye Body is a partner in Alukanoye Body, has agreed to do a presentation. I think later in the year as well. We have some other people that are not confirmed yet, but as soon as we have confirmation from them, we'll let you know. And then another thing is this presentation is being streamed live on YouTube. So what that means is that the presentation will be available on YouTube after this seminar. So those who want to probably go and look at it again to have an idea of what this is all about, you're free to do so. So thank you so much once again, Ibukun. It's nice having you here. Nice seeing you again.
Yes,
like I said.
Lovely to, and I had a lovely time. I look forward to the to the next ESG seminar. That would be very good.
Yes. I'm sure we'll do that at some point in the year. I will let you know, certainly.
Yeah, thank you.
All right. All right. Thank you so much to all our guests, and I wish you a very pleasant weekend ahead.
All right. Thank you.
Yeah, we've come to the end of the seminar. Yeah. Bye-bye.
Yeah. Thank you so much. Bye.